Rochester Television Fourth Department. Hear ye, hear ye, hear ye. All present have present before this court with God here for the attendance that shall be heard.
Please be seated. Take it in. Today is a momentous day for our Fourth Department family. As you can see, the seats are filled and the walls are lined with our incredible staff here to mark Justice John V. Centra's last sit in this wonderful courthouse. I would like to acknowledge Judge Centra's law clerk, Colleen Farrell, who is here today, and his legal assistant, Erica Gallucci. They're here today to honor their judge on this special occasion. Justice Centra joined this court in October of 2006, almost 16 years ago. In record time, about 15 months, he went from the most junior jurist to a justice presiding, sitting in the center chair. It is estimated that Justice Centra has sat on over 10,000 cases and more than 70,000 motions while a member of this court. He has put the time in and worked extremely hard and long hours to be ready on each case that he was charged with considering. Early on in his career, he was taken under the wing by then Senior Justice Samuel Green and mentored by the likes of Justices Gorski, Hurlbut, Pine, and others. Justice Centra soon understood the importance tradition plays in the day-to-day operations of our court. He understood, he was made to understand, that the traditions of the court are what sustains the institution itself. Once this realization settled on him, he became a most faithful keeper of the flame. He has been the central figure in upholding the court's traditions, and in doing so, he has instilled in the rest of us the importance of court protocol, the doctrine of stare decisis, and the value of collaboration in pursuit of justice. I can say, without hesitation, that he is looked up to and incredibly well respected by every member of this court. When Justice John Centra speaks, his colleagues listen. He will be dearly missed, as much for his thoughtful participation during conference and the disposition of cases, as he will be for the ability to keep the court collegial and a pleasant place to work. On behalf of our supremely talented staff, the court members, and the legal community, I say thank you for your dedicated service, and we all wish you well in the next chapter of your life.
For those of you who aren't staff members, the clapping and applause was on direction of Judge Whalen to our staff, or they wouldn't be paid this week. I'd like to start out by thanking P.J. Whalen for those kind words. Thank God he wasn't under oath. I'm going to save my comments and thank yous to my family and mentors for next week. I'd like to address my Rochester family. Everyone in this building, from maintenance to the clerk's office, have been nothing short of outstanding. I've never worked with a more dedicated group of people. The permanents, pre-cert, they've always had our best interests at heart. There may have been times where I didn't agree with them, but that was strictly just a difference of an opinion. I'd like to thank them for putting up with me for all these years. 16 years ago, when I arrived here, I truly was a fish out of water. I only knew Justice Hurlbut. At my first conference, I wasn't saying much until Justice Green said to me, "John, Your vote is just as important as any of ours. That really hit home. By the time I left the first term, I felt as a welcomed colleague. I've been fortunate enough to have served with over 20 different justices. The institutional knowledge that I gained from Justices Scudder, Green, Gorski, Hurlbut, Martocci, Pine, and others, I've tried to pass on to my newer colleagues. I hope I was as good a colleague to them as those before me were to me. I've been fortunate to serve under two hardworking and dedicated presiding justices, Justice Scudder and Justice Whalen. I have great respect for what they do on a day-to-day basis. Thank you, Justice Whalen, for your exceptional leadership of this court. When asked what's one of the things I'll miss the most, other than the collegiality of my colleagues, that was simple. The dinners and the socialization after dinner. Understanding and knowing about your colleagues is very helpful, especially when you're in a battle over a case. I have truly made lifetime friendships here at the Appellate Division. I'm going to leave this short today. Last but not least, you've heard the saying, I'd rather be lucky than good. Well, I was. In the summer of 2006, my law clerk was retiring and had to find a new one. Not knowing if I was going to the Appellate Division or stay in the trial level, I was lucky enough to find the hardest working, most dedicated law clerk any judge could ask for, and that's Colleen Farrell. She's been by my side throughout the last 16 years. We've never had a cross word, and I've never been upset with her. Although I don't know if I can say the same about her. Colleen, I wanted to acknowledge you here today in front of our colleagues to say thank you for what you've done for me. In my eyes, you are truly the best. I've had a great run, and thanks to all of you, have made my life and my career as good as it was. May God bless.
Okay, very good. Thank you, everybody who's in attendance for the beginning of our sit today. We'll now get on to the calling of cases. The first case on for argument today, case 647, People versus Lewis.
Good morning, Your Honors.
While we wait just 1 second, Counsel, until everybody gets situated. That way we won't be interrupted. Okay, very good. Counsel, please proceed. Thank you.
Thank you. Good morning, Your Honors. Connie Lozinski on behalf of the appellant Denzel Lewis.
Counsel, could I ask you to stand in front of the podium for...
Thank you.
The only reason is we have a camera on you, we're live streaming, and people want to see you.
Your Honor, a defense counsel's job does not stop with the entry of a plea. While myself, when appearing as defense counsel, I can admit I do not always prepare a pre-sentence memorandum or do any crazy preparation prior to sentencing, but this was a case that screamed out for exactly that. After the sentence, after the defendant's plea, the judge invited defense counsel to put through any arguments that they may have in mitigation of the defendant's plea. Secondly, Your Honor, 3 months before the sentencing actually took place. A pre-sentence report indicated that the victim's family was very upset and that they were planning to put in statements from the victim and the victim's family. Defense counsel had 3 months to prepare for this. Prior to, and it was in the record, there was a skirmish between the defendant and the alleged victim, where the alleged victim pistol whipped the defendant. Also, at the scene of the incident, the victim had 2 guns in his pocket. The defense counsel did not put any of that into play.
Counsel,
Yes.
isn't it fair to say that the court, from the transcript, the court was aware of these facts?
The court was aware of the pre-sentence report, Your Honor.
No, but aware of the facts of what took place of the
Yes.
incident? I mean, so some of the stuff you're mentioning here today, the court had prior knowledge of.
I agree that the court had knowledge, but none of that was emphasized at sentencing, Your Honor. It was
But it
months.
certainly was in the ken of the judge, so the judge knew all this, and perhaps the defense attorney didn't have anything extra to add to what the judge already knew. There might not have been any other mitigating circumstances that the defense attorney could come up with at that time.
Judge, but they could have been presented in a way that would overcome the victim's family's efforts in sentencing. When the victim's family makes more efforts in sentencing, Your Honor, the victim's brother, half-brother, was to be a professional football player. I can only say football player. I can only say, thank goodness he wasn't a Buffalo Bill, or perhaps the client would have been sent to life. I don't mean to make light of that.
Well, he was given an offer of a reduced plea that took life off the table. So that's not really.
It did take life off the table, Your Honor, but the factors, the defense counsel allowed both the judge and the victim's family to say this was a premeditated murder. And it wasn't.
But once again, the judge is well aware of all the facts of what went on here.
The judge was aware of facts, Your Honor, but again,
If there was
none-
something extra that could have been brought forward, the defense attorney could have done that. but
At the time of sentencing, Your Honor, the alleged incident took place in the daylight, took place in a public area where cameras were known to be all around. If somebody was staging what the judge referred to as an assassination and a murder, would they have done it in the morning, in a public place, with cameras all around? The judge mentioned that he watched a video that had never been authenticated or given the ability to be refuted. Defense counsel had evidence that there was an alternate video, a different angle.
Again, though, this isn't the trial, this is at sentencing.
We understand, but the defense counsel could have brought this up. When the judge mentioned he watched a video, the defense counsel could have mentioned the video they watched, which saw the victim reaching into his pants.
Your concern is, I think, at least in part, that as this sentencing unfolded, it was lopsided. There was one side speaking out, and they were speaking out in a very emotional way. The judge's reaction to that seemed to be a little heightened in reading the transcript. And your argument is that the defense attorney had an obligation at that point to balance this, to make sure the judge understood that there was another side to this argument, and in your opinion, in your view, the judge failed in that regard.
Judge, and
Not
that
the
is-
judge, the counsel failed in that regard.
That is my argument. Under 38050, counsel had an opportunity to rebut all these statements and falsities that were made during sentencing, that the victim was gunned down in the back, which was absolutely
Yeah,
not true from the evidence.
the fact that that information is contained somewhere in the record
That
before
is
the
correct.
judge is not enough. Your view is the purpose of the lawyer is to be the mouthpiece to articulate on behalf of the defendant, and your argument is that he failed in this regard.
That is correct, which gives me a segue into my second argument. Because of the failures of what we perceived from defense counsel, it led to an unduly harsh and excessive sentence in this regard. Mr. Lewis was 21 years old, granted an adult, but a very young adult.
No priors?
no priors whatsoever. There's not
Which is a substantial factor in considering sentencing,
We're
correct?
not even a mention in the probation report of a traffic ticket. He had great family support, which another thing was not brought out by defense counsel. Lastly, Your Honor, he had a plan to move out of the area, away from whatever issues that he was getting himself involved with. Lastly, Your Honor, there were newspaper articles which indicated that the judge had indicated that he was going to consider something less of a sentence. Newspaper articles. I myself tried to even contact the reporter who reported on this to find out what made him write that in the newspaper, which also gave my client some kind of indication that it wasn't going to be 25 years. And again, there were discussions in chamber about lesser than the max, that unfortunately, that's the defense counsel never secured any type of a sentencing commitment, even though we believe that those conversations were had.
I think we have your argument, counsel. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, my name is Carrington Crossley. I'm representing the Niagara County District Attorney's Office in regard to this matter. I'd like to briefly respond to appellant's argument with regard to point 2, that the defense attorney was ineffective. Essentially, appellant's argument is to question the strategies employed by defense counsel at sentencing here, to question why he chose not to say certain things, why he chose not to do certain things. I'm arguing today that the legal standard is simply whether defense counsel was familiar with the facts and circumstances of the case and familiar with the defendant to make a meaningful argument on his behalf. And the transcript makes clear that he did that in this case. He referenced to the court at sentencing the appellant's youth, his lack of criminal history, also referenced that he turned himself in after the crime, and he did make reference to the history between the victim and the defendant. I would argue that those facts illustrate that he was familiar with the facts of the case and familiar with the defendant himself, and did provide meaningful representation at that time. In response to appellant's argument on point 3, that the sentence was unduly harsh and severe, I'm arguing today that the facts of this case in themselves warrant the sentence given by the trial court. Appellant argues that the representation that defendant shot the victim in the back is inaccurate. We do have in the transcript evidence that the bullets struck the victim in the buttocks on the left side. We have evidence that the defendant sought out the victim, approached him from behind, and shot him repeatedly from that angle and fled the scene. Those particular facts were interpreted by the trial court as resembling an assassination, which is particularly brutal, particularly heinous. Although the defendant was 21 years old, the pre-sentence report illustrates that he completed 11 years of education, which would mean he was out of school for about 4 years, which is plenty of time to develop an appreciation and understanding for the consequences of his actions. If there are no further questions on these points or point 1, I will rest on my papers.
Very good. Thank you, counsel. Case 648, People versus Thomas. Proceed, counsel.
Thank you. Good morning, and may it please the court, Carolyn Walther for Adam Thomas. The only evidence directly connecting Mr. Thomas to the robbery in count 3 of the indictment was a single fingerprint on an exterior door of the apartment building where the robbery took place. There was no identification of Mr. Thomas as the perpetrator. There was an extremely minimal physical description given of the person responsible for this. And so, as I argued in my brief, not only was the verdict against the weight of the evidence here, But there was good cause to sever the counts of the indictment from one another, especially with respect to this count 3.
We'll take a look at that. Would you address the alibi notice issue?
Certainly. Counsel placed on the record the fact that he negligently failed to file the alibi notice in a timely way, and asked the court for permission to file this alibi notice. This would have been a critical piece of Mr. Thomas's
This isn't a
defense.
case where the defendant revealed the alibi information on the eve of trial. In fact, the record seems to indicate that the defense counsel had this information well in advance of the
That's-
trial date.
Yes.
And just failed to properly notice it.
Yes, and he was very candid about that fact on the record. He admitted that this was an oversight on his part.
I think my reading of the record is also the fact that instead of the court articulating or reasoning what the standard is, the court just didn't believe that an experienced lawyer would have forgotten this after a number of appearances that they made. The court felt that it was a gamesmanship or some type of maneuver being made, although he said I'd give him the benefit of the doubt that it wasn't. But it didn't seem like the court really articulated or got into the standard of review on lateness of alibi. So
I
that's-
agree.
That I think is a problem.
Yes, I agree, Your Honor, and there really wasn't factual support, I would submit, for that sort of conjecture that the court was making, that this was a tactical error, beyond the fact that this was an experienced attorney, but as we all know, even very experienced attorneys do make mistakes.
Fair enough.
And in this case, the mistake was critical enough to deprive Mr. Thomas of the effective assistance of counsel. This alibi would have obviously been a very important part of his defense on these 2 counts. Defense counsel submitted no evidence other than, I believe, a single photograph that was introduced on cross-examination, called no witnesses. So without this...
Yeah, the proof wasn't otherwise overwhelming, is what you're saying.
Yes, certainly, certainly. If there are no further questions on those points, I'd just like to briefly address Mr. Thomas's sentence. As the court is aware, he was offered a potential plea that would have involved 12 years in prison. He's currently serving an aggregate term of 27 to 30. And obviously that's a substantial difference, but the court really didn't place on the record the reasons for imposing such an increase.
But you hope we don't get to that issue.
Hopefully not, but I did, for my client's sake, want to make sure that
Of course.
that's obviously
Thank you,
something.
counsel.
Thank you.
Good morning, Your Honors. May it please the court, Lisa Gray for the people. With respect to the late alibi notice, as Justice Centra, you pointed out that the information was gleaned, I think, shortly after Mr. Thomas was arraigned. And there was a delay, I think, over the course of this case that took about 7 months. There were 6 court dates, there were plea
You know what
negotiations.
I found unusual, counsel, is that not only did the attorney say that there was disclosure by his client, but he had an investigator look into it, and it seems to have verified, at least my gathering of the record, it seems to have verified the actual potential validity of a defense, and he was aware of it. And a lot of the cases you cite to really deal with, it's last minute, the defendant comes up with it, the defendants now has an alibi after 6 months or 8 months. This is one where right out of the gate, name, person contacted, person verified, and the lawyer drops the ball. And it just seems to me that, are we not punishing a defendant in this situation for the lackluster performance of his attorney?
Not necessarily, because if you look at the entire trial, defense counsel's performance was certainly not lackluster. And also, I think it's also important to note that the trial court didn't want to prejudice the people either. I mean, the
Well,
people
how
lost
would
out
it-
on months of being able to investigate and speak to this particular witness and either confirm or rebut whatever this witness was going to say. And in this case, there was an elderly, certainly a very elderly victim. I think there was even like a mention of the fact that, you know, she had a doctor's note and the doctor was saying she probably shouldn't testify, but she wanted to anyway. I mean, from the people's perspective, the fact that this attorney, this experienced attorney over 7 months, just did not file any sort of notice, that certainly put the people at a disadvantage as well. And the court noted
But
that.
it's no fault of the defendant. A lot of those cases you cite to, it's the fault of the defendant. And this is, I think this is where it's a little unique, is that it's not the fault of the defendant. There's other cases, you can say the defendant, you know, he made his bet, he chose to do X, Y, and Z. This case, he did exactly what he was supposed to do, and the lawyer did, but didn't follow through with the step. But we'll look at that issue.
And just with respect to the weight of the evidence, I mean, obviously in this case, identity was certainly an issue. But with respect to count 3 of the indictment with Ms. Blaskivunas, you know, it was more than a fingerprint hit. I mean, Ms. Blaskivunas, although the description was minimal, she was able to say that, you know, the man was black, he was sitting next to he had a hoodie on. When she got up from the bench to head to her apartment, she noticed that he also got up from the bench. It's page 174 of the transcript. Her description of the events, you know, the jury could infer, and properly infer, that that person followed her to the apartment. And, you know, the testimony was also corroborated from the neighbor who gave Ms. Blaskivunas assistance. There were 5 units in an apartment. 1 was vacant. He occupied 1. Ms. Blaskivunas occupied 1. There was another woman named Priscilla in that apartment. So, you know, the jury, you know, was able to properly infer all these things, that the man sitting next to her on the bench was the man who showed up behind her, knocked her to the ground, took her purse, and left a fingerprint behind. So
Are you
it's a little bit more than a fingerprint.
A little bit more than fingerprints, but I'm trying to understand it. Is your argument that therefore the proof was overwhelming? You're not saying that. You're not going that far.
I think you absolutely, there's proof beyond a reasonable doubt with respect to count 3 that this particular defendant committed this robbery. And drawing all those reasonable inferences from all those facts that were elicited at trial, the jury was able to infer beyond a reasonable doubt that this particular defendant committed this particular robbery.
But at the end of the day, does it really matter one way or the other than a conviction, because the sentence doesn't change? Right? I mean, the sentence, would this affect the sentence?
Well, they're consecutive. There's consecutive sentences, so certainly. I mean, if this count is reversed, then Mr. Thomas's sentence gets reduced by 12 years. So it does affect the sentence. I'm sorry, Justice Winslow.
I just was going to say, you certainly would be in a much stronger standpoint if the 90-some-odd-year-old victim hadn't had her glasses knocked off and had testified that he had touched the doorknob or the door where the fingerprint was. He didn't have any of that. And, you know, the case that you cite that you tried to analogize to was much stronger, because that involved a vehicle that was a stolen vehicle that was used to flee, so there was knowledge that that individual had been inside that vehicle. So I just think you're in a tough spot on the fingerprint.
Well, again, I'm sort of looking at, you know, every single tiny fact that was elicited during the trial and the inferences that could be made all come to the conclusion that, as to count 3 anyway, this defendant was guilty beyond a reasonable doubt.
We'll take a look at that, counsel.
And unless there are any other questions, just with respect to the sentencing, I would just ask that this court not modify the sentence. This defendant was on probation for an attempted rob 2 before, about a month before he committed the robbery in August of 2013. These were vulnerable victims, especially fragile victim in this particular case. The other 2 victims, I think, had a little bit of fire in the belly, so to speak. They fought back a little bit. Ms. Blaskivunas didn't, and she was injured. So for those reasons, Your Honors, I would ask that this court affirm Mr. Thomas's conviction in its entirety.
Thank you,
Thank
counsel. Case 652, People versus Savory. Proceed, counsel.
Good morning, Your Honors. May it please the court. It was an abuse of discretion for the court to allow in so much Molyneux evidence in the interrogation video to be shown to the jury. It's really not true that all of this evidence about gang affiliation was volunteered by Mr. Savory in order to convince the court of his innocence. If you watch the video, the majority of that conversation, which was extensive, was because police were asking him general questions about essentially how the blood gang works. That wasn't related to this incident, wasn't related to these people, and it was just general questions of, for instance, what's the territory? I would ask the court specifically to take a look at from around 1745 to around 1754 on the video. There's a 8 to 9 minute period where there's just a discussion just about gangs, and it's not specific to this case, and it doesn't really have anything to do with this incident. It's just police asking him questions. For instance, how do you check if somebody says they're a gang member? How do you check if they're legitimate? What are the consequences and discipline for breaking the rules in the gang? What's the lingo that you guys have? What's everybody's gang nicknames? All of this stuff, not only was it not more probative than prejudicial, it wasn't even relevant to anything. And so the fact that even all of that conversation was let in, I think really demonstrates that the court was not properly exercising its discretion in limiting this to only proper and necessary Molyneux evidence. During that same time period, there's a long discussion about nicknames, and police elicit from Mr. Savory that his gang nickname is Rampage the Gorilla. Even if this didn't have anything to do with gangs, that wouldn't be allowed in trial. As the court is aware, nicknames that imply violence aren't allowed to be admitted for no reason. That should have been taken out of the video. Police asked a lot of questions. Mr. Savory made somewhat of seemed an offhand comment about Mr. Padilla, who really was not involved in this robbery, saying that him leaving was not very jet-like. It was marginally related to the story he was telling, but they asked a lot of questions about that, even though it really doesn't go to any issue that the jury had to decide.
That's what we have to look at all that very carefully and decide whether or not these do go to the issues.
Correct. So that sort of all goes to the whether this completed the narrative, and we argue that most of it absolutely did not. The second reason that the court let this in was to demonstrate the relationship between the parties.
And that is very relevant.
It can be in some cases. It's not here because these parties didn't say we all got together because we're all in the Bloods gang. Them getting together that day didn't have anything to do with their gang affiliation. First of all, it's not clear from this record that any of these people knew each other through the Bloods gang. Mr. Savory and Mr. Powell were childhood friends. Both of their mothers said they grew up together like brothers. So the Bloods gang had nothing to do with their relationship at all, except they just both happened to join the Bloods when they got older. The other 2 or 3 men, they were in the Bloods too, but nobody said, this is how we met each other, this is why we were together this day. Nobody said we were doing an official Bloods hangout. It was just sort of an ancillary fact that...
Wasn't there testimony, though, and correct me if I'm wrong, that they were members of the same gang but different factions of the gang? And doesn't that kind of go to filling out the narrative as to why one gang member might have shot another gang member? Well,
importantly, the trial court did not allow this evidence in for motive purposes. The prosecutor argued that it was relevant.
Again, it's not necessarily for motive, but again, just to complete the narrative and to figure out what's going on here, that testimony is certainly relevant.
It didn't play any part in the incident. The fact that they were from different factions, Mr. Savory said during the interrogation that these 2 factions got along with each other. They kept their business separate and they didn't really have anything to do with each other, but they got along, they had no problems with each other. For those purposes, they were just all Bloods and they wouldn't have gone after each other.
We'll take a look at it.
I just like to address the prejudice in terms of harmless error. One, it was more prejudicial than probative. And I would ask the court to look at page 762, which is the people's summation. where the prosecutor argued that because Mr. Savory was in that culture, he would take action against Mr. Powell, and that he says, a gang that obviously Zakai Savory really speaks highly of and is really intimately involved in. You can tell from that interview. So he's using all of these references that he got into evidence that he's not supposed to use for this purpose, and saying, this is a guy in a gang who really, really likes this gang. He probably committed this crime.
We'll look at that very carefully.
Thank you. Just final thing, if the court does reach the issue of sentence, there's a defense pre-sentencing memorandum in this case that I think sheds a lot of light on why this young man at such a young age got involved with gangs and crime. And I would ask the court to take a look at that, because 41 years to life is an extraordinarily long sentence, and he has the potential for rehabilitation. And so we would ask that the court allow the parole board to look at him sometime a lot sooner than 40 years.
Thank you, Counsel.
Thank you.
Good morning, Your Honors. May it please the court. Ken Tyler for the people. I'm not sure some of these very highly particularized arguments are really preserved for review this morning. Defense counsel kind of came in on the morning of trial and said, I just realized the whole video needs to be excised. Irrespective of that, I submit to you that for the reasons Justice Smith identified, this was highly relevant evidence to explain kind of the context of these witnesses' knowledge of each other. If it were just these two were childhood friends, that doesn't really tell you a whole lot about what's going on here. I think obviously essential to this analysis was the curative instruction as well. For those reasons, I'd ask you to affirm. Congratulations, Justice Centra.
Thank you, Counsel. Case 653, Wilson DeJesus versus Vlasic.
Good morning, Your Honors.
Proceed, Counsel.
At the beginning of family court's best interest analysis, in this case, the court writes that the scale falls almost even. I disagree with that. I think the scale clips clearly towards granting the mother primary placement of this child, and the court's conclusion otherwise lacks a sound and substantial basis in this record. One of the most important factors I would ask this court to look at is that the father has shown himself to be a bad co-parent, and I think family court ignored that. Starting with July 2020, the father absconds with this child and her older sibling. He removes her from Monroe County, takes her for what is supposed to be weekend visitation to Erie County, but he never returns the children. And I think crucially, at that same time, he blocks the mother's phone number, cuts off all contact with her, and relies upon this 14-year-old child to start being the person who will go between the parents. There's other communication problems in this case. The father does not communicate with the mother about school or about medical matters. And I think that his testimony sheds light not just on his actions, but his attitude towards this aspect of co-parenting. So when he moved in Erie County and the child's school district switched to a new school district, the father didn't tell the mother, and he testifies that he didn't feel it was necessary to inform the mother that the child was in a new school district. And as to medical evidence...
Counsel, the record reveals that the child had some mental health issues that seemed to do a lot better when the child was with the father, as opposed to the time when the child was with the mother. And that seemed to weigh heavily in the decision to give the father custody, despite all of the issues that you have recognized with regard to the father's limitations. That seemed to be the big issue and the big reason. Can you speak to that at all?
Yes, Your Honor. So I think that is the mental health issue is one of the issues that family court did focus on a lot, and that the AFC does focus on appeal as well. And I think that the child's reporting that her mental health is better, and the father's testimony that the child apparently had better mental health staying with him, it is intertwined with the other reasons that the child is wanting to stay with the father. And those are his leniency and the money that he's giving her. And I think...
Well, that seems to be the basic truth. The fact that you're claiming that he's lenient, lets her smoke pot or drink, gives her money. The record reflects that she was cutting herself prior to this. and it appears that she is not doing that any longer. And unfortunately for you, you're not, you don't have access to the Lincoln hearing that was done here, and what the child told the court at the Lincoln hearing regarding her mental health, what took place in the mom's house, and also, I know it's unfair, but unfortunately, these are the rules of family court. But as Justice Bannister pointed out, it appears that her mental health, and significantly, including her grades in school, that she's doing much better in the father's care. Why aren't those factors that the court should weigh heavily when we're dealing with a person of her age, along with mental health, depression, and other issues that she has?
So I think that that's a great question, and of course, not knowing what's in the Lincoln hearing, I'm sort of treading blindly into this area.
I recognize that.
But one thing that I would point out to the court is that sometimes what a child wants and what a child desires is not what is beneficial to the child.
And I agree, it's what a child wants is not, it's not totally controlling, but it's a factor, I think you would agree with me, it's a factor the court may consider.
It is, and I think that some of the father's ex-girlfriend's testimony sheds light on why the child is getting what she wants, which may be beneficial for her mental health in some ways, but that getting that may not, in the large scheme of things, be a beneficial thing for a child and not in her best interest.
Counsel, isn't there some bias potentially on the part of the ex-girlfriend that needs to be considered when looking at what she said?
I think that's an interesting question, and I do view this ex-girlfriend as a neutral witness. She testifies that she doesn't know the mom, and unfortunately, I don't have a record citation for you right now, but the ex-girlfriend testifies that she cares about these kids. They lived with her for about a year, and she is speaking as a parent and as a mother herself. She's got her own child. She doesn't know the mom, but she's just sort of speaking about what she would want for these kids. So I don't think, she doesn't appear to have a grudge against the father in her testimony. It does appear to be neutral testimony, just expressing her concern for this child. And one of the things that she's saying is that the father would just let this child stay in her room all day. The father wouldn't invite her to go out on a walk, wouldn't have family dinners, would just say, hey, the kids will eat when they're hungry. They'll come get food that they want.
I mean, it's not just the father's view of this or the ex-girlfriend, but this child had been seeing a counselor, and the counselor apparently was saying she doesn't need counseling anymore. So it's not just, there's a neutral person out there that's saying, yeah, this child's doing a lot better with her mental health issues.
I would point out, Your Honor, that testimony does come in through the father. We never had any of the counselors testify. We never had any reports of the counselors. All of the information about the child's mental health is being reported through the parents in this case. And so, I would just ask Your Honor to take some of that with a grain of salt. Again, I haven't read the Lincoln hearing, so I don't know how the child has reported her own mental health concerns. But I think the father is just letting the kid stay in her room. And one of the things that the ex-girlfriend says is, the kid appears to be an adult and appears to be making these decisions, but I really feel that she needs somebody to push her, to draw her out of her room, to engage her with these activities. And these are the things that she was getting more at the mother's house. She was involved in more extracurricular activities, more music activities at the mother's house, and the father himself testified that he couldn't afford to pay for some of these extracurricular activities.
I think the point's well taken, Counselor, but once again, we look back to see it appears that her mental health and things and her grades in school have improved since she's been with the father. I understand that she was doing more with her mother, trombone and other activities, but it still appears. And I think the court had to make it's something more. Well, look, these are, as you know, these are difficult cases even for this court. So.
Yes, Your Honor. If I have time, I would like to just touch base three quick things.
Very briefly.
Continuity. Child lived with the mother for 14 years. Dad was absent in her life for 6 years. Continuity in the length of the prior custodial agreement is an important factor. Separation from siblings. This kid has 3 siblings in Monroe County, and that was not a factor. Family court did not consider the need to separate this child from her 3 siblings in placing her with the father in Erie County. And again, I think this is akin to a relocation petition, and I don't see an overwhelming need for the child to be removed from the community she's been in for 14 years.
We'll take a look at it. Thank you, Counselor.
Thank you, Your Honors.
May it please the court. May it please the court. Gary Muldoon on behalf of the child. As noted in my brief, I've reviewed the Lincoln hearing and I've also met with the child. I spoke with her 2 nights ago. She's attending school in Cheektowaga at Maryville High School. Last year, she was in AP History. This year, she's in AP American History. She's involved in gym with her father, a concern that she had with her weight. She is, along with the AP class, she's playing trombone. She seems to have her act together. There's good reasons for her to be with her father, and there's also good reasons for her to not be with her mother. There was a toxic relationship between the child and the mother's boyfriend that seemed to be festering in this case. Does the father have weaknesses? Yes, I agree with counsel that the father was absent in the child's life for several years. That is a consideration, but the father has stepped up and acted appropriately. This is a father who is, in a very real sense, a role model for this child. He is employed. He's in the Army Reserves. He's in Air Force Reserves. He's in, he's a nurse. The mother, as best I can tell, as noted in the record, is surviving on either her boyfriend, who lives in the same apartment complex, or on child support from other people. So there's reasons why the child should be living with the father. Now, the two of them are not that far away, and I would note, Your Honor, that the court considered and kept up with joint custody, including giving the mother greater time during the summer, so that Gabriella is able to see her older sister, for example, Dahlia. They have a decent relationship. So that kind of relationship continues on. The parents have a poor relationship. It's so many cases that you see where they're reduced to texting each other. They are both supportive of Gabriella, and it appears that Gabriella is doing a good job.
So the mental health issues that she had, the suicidal tendencies, the self-destructive, that's all gone now?
As best I can understand, yes, Your Honor, it is. From speaking with the child and from my review of the Lincoln hearing, that does not appear to be a current issue. Justice Winslow, as to your question of the possible ex-girlfriend testifying in a bias, boy, we all have ex-girlfriends and ex-boyfriends who might have a problem with how we are doing things in life and want to get back at us. Whether that was a factor, I don't know, but I really question almost the relevance of allowing this ex-person to be involved in testifying in this case. Perhaps she shed some light. I would note that the AFC in this case moved, and the judge granted the AFC's request that the child be allowed to live with the mother during the pendency of this hearing. So this is a relationship that has continued on for a significant period of time. And on behalf of the child, I am requesting that the decision of the court be affirmed, that there is a sound and substantial basis for this finding.
Thank you, Counsel.
Thank you.
Case 654 through 660 in the matter of Brianna S., Xavier S., and Kaylee S. Counsel?
May it please the court, Bridget Fields on behalf of Ricardo Sample. I'd like to address my third issue first, the fact that Mr. Sample wasn't present on the first day of trial in the permanent, in the neglect portion of this. Mr. Sample had been in the Genesee County Jail and had been removed to the Wyoming County Correctional Facility. The court had been advised of this. It was indicated in the dispositional plan.
Yeah, it seems like the ball was dropped. There wasn't a transfer order to bring him over to court, and so no fault of his own, certainly.
Correct. Fault of the court and potentially fault of his counsel for not making sure that he was there. The court proceeded. There was a day, actually an afternoon of proceedings. There was arguments on motions, arguments on the admission of evidence. Emily was called as an adverse witness while.
So do we look at the totality of the proceedings, or is it just enough that he missed that part and therefore his rights have been violated?
I think it's enough that he missed that part.
Okay.
This was the first witness. It was an adverse witness. He wasn't there. The various counsel responding in this matter have said that things like time was of the essence. Well, this was October 31st, 2018. A decision wasn't issued until March 6th of 2020. So putting this off a day, half a day, there was testimony the following day, certainly would not have hurt these children in any manner to go forward. So I think it's an all or nothing argument, honestly. And I ask that the court look at this both in the court's failure, the family court's failure to do this, as well as an ineffective assistance claim by defense counsel for failing to make sure that his client wasn't present. Moving to the first issue, I would argue that the court did not establish, that the DSS did not establish due diligence by the department in terms of meeting Mr. Sample's needs in this case. Unless the court has any questions.
No questions? Thank you, counsel.
Good morning, Your Honors. May it please the court. I'm Kellyanne Argian. I am here on behalf of the mother appellant, Emily Schramm. I have a couple of points I would like to address, and specifically, I would like to start with recognizing that parental rights do not evaporate because of not being a model parent or losing temporary custody to the state. And we are acknowledging that mom was not a model parent, but mom found herself caught in a system that is not flawless. This system is full of flawed people, unqualified people, and people without children even, to be able to dictate how somebody who has children parents. That being said, the mom has a significant interest in this court reviewing the entire record and scrubbing it, because there are many, many contradictions. There are many, many points where the respondents themselves find that or report that mom is, that they deem the home safe and the children comfortable and happy, but yet 2 days later there's a finding of a violation by the court. There is many contradictions, as well as the fact that mom is attacked from every angle in this case. For example, there was a trial discharge. The children were removed from that trial discharge specifically because the caseworker believed mom was going to be arrested. It is in this record. It doesn't matter. None of the other specifics about it matter. That's what she testified to. She believed that. But you will see in the record that prior to that, one day before, this caseworker was also aware that there could be a possible arrest. And they had a conference, and all the attorneys were together. And this caseworker does not reveal this. That's a travesty. That's just adding this system that is not flawless, added to everything this mother did throughout this 4+ years that she's in this system.
Well, there wasn't just that one trial period. There were multiple trial periods, and they were of very short duration for a variety of reasons.
Well, for example, you might be talking about the one with the son earlier on. There was that, it can be argued that the reason is because of a boyfriend, but mom was trying to get the boyfriend approved, and the boyfriend ultimately did get approved. This mother was so scrutinized continually that she couldn't even make a decision to let her oldest daughter go to the store with her grandfather. That was used against her. Every single thing she did was used against her. If you scrub this record, you will see that. Mom became, after so much time in this system, she was put in a cage. She couldn't do anything right. And we also have to remember that mom Mom's true underlying problem is that she was a victim of historical domestic violence. So Mom's behavior was related to that, yet nobody cared enough to say, okay, let's not think about all these other orders in these dispositional orders, but all these other things that we could do. But what about this underlying true problem? Mom was just told, go make an appointment and get a certificate that you completed domestic violence classes. Well, she's in a pattern. She's in a cycle. She can't break it. She needs help with that. And she doesn't need a parent aide coming in and telling her how to feed her children. That's not what she needed. And this was continual.
Wasn't the parent aide there because of the way that she spoke to the children and the multiple examples of inappropriate parenting behavior?
I don't see her as being in there for that purpose specifically, but I will say to you, and I will acknowledge, and Mom will acknowledge, that she lost these children because she does have a belligerent mouth. But it's also because she was a victim of domestic violence. It is not a question of anything else than the system added to the problems. And here we are, right? How many years later? And this poor mother was up against people who can come in and tell her every little piece of her life, what she was to do all day long with these children.
Well, Counselor, but it did begin with an issue of educational neglect, shall we say. Her kids not going to school. Now, that didn't happen because people were all around her. That happened because that was when she was on her own making those kind of decisions, allowing the children to not be present at school for extraordinary amounts of time.
And if you scrub this record, you will see that it was due to transportation and it was resolved. But who did Mom reach out to? She's in the pattern. She's a domestically abused woman. She's in the pattern. She reaches out to Dad. Dad's helping her. There's more conflict there. That was an issue. Yes, that's how she found herself in the system. But 4 years later, after being deemed having a home safe and children are comfortable and happy, and she's violated again and has to undergo this for another year again and again, this happening, eventually you're going to fail. And that's what this court needs to look at.
We'll take a look at the total record, Counsel, on that.
And I just have one more point. I'd really like to point out the fact of the doctor's report that was introduced at the very end of these proceedings. Briefly, he has a host of diagnoses. If this mother was full of all these diagnoses that I can't even regurgitate, she would have exhibited far more problems early on, and she also would never have been able to accomplish any achievements, which she did. She had successes. The respondent reports to it. So these diagnoses, if they were to come out earlier, she would have had a chance to defend against them. She never did, and they were used against her because it's in the court's findings. And that is a travesty that this introduction of these diagnoses was so much later. And if they were true, then she's also lost the children due to a mental defect. And hence, she had a right to cross-examine this witness, and the court should have looked to this witness to come in and testify to these findings, because that's what our case law says should happen.
Thank you, Counsel.
Thank you.
Good morning, Your Honors. I'm Susan Gray, and I'm the attorney for the child Kaylee. Today is Kaylee's birthday. She's 12, and I would argue that the real travesty in this case is that my client has been in foster care for a total of 42 months. As I indicate in my brief, and I think is present in the record, services were continually offered to both the mother and father, which they refused to engage in. And I don't think there's any dispute that the mother didn't even engage in mental health treatment until the first day of the dispositional hearing. So on Kaylee's behalf, I would argue that her best interests have not been served by this case taking so long in the lower court. She is living in a foster home where she is happy. Her sister Brianna is with her. The foster mom intends to adopt, and Kaylee is in favor of that.
Thank you, Counsel.
If you have no other questions, thank you.
Good morning, Your Honors. May it please the court, Vera Vankova. I am the attorney for the child, Brianna. My client was 12 at the time of this termination proceeding and the disposition, and she is 15 now. And
She's 15 now?
she is, Your Honor. And I'm cognizant that my position on appeal is different from the trial AFC's position. Over the last 3 years, my client's position has evolved, as the court was just advised. My client is in a pre-adoptive foster home with her sister. And at this point, my client would consent to that adoption, and it is the finality that she is looking for. She's doing very well. So I would ask the lower court's decision to be affirmed in its entirety, but I would be happy to answer any questions that the court may have.
No questions, counsel. Thank you.
Thank you.
Case 662, Harrington versus Cutton, excuse me. Proceed, counsel.
May it please the court, Kerry Muldoon for Justin Cutton. In any Tropea relocation case, the parent seeking to relocate has the burden of demonstrating economic, educational, or emotional reasons. The mother showed none of these. Her reason was plain and simple, and it was also obvious. She wants the father out of her life. These parents lived together in Allegheny County and split up when the child was about 2.5 years old. At first, she continued to living in Allegheny County, and she even bought a house in Allegheny County. But then she found a boyfriend in another county. Actually, they lived together in Allegheny County, and then she married and moved out of county. The distance increased between the two parents' locations to 68 miles, so that the round trip difference is now 3 hours versus about 40 minutes before. It's a significant difference that kicks in a Tropea analysis. Now, the judge found that the mother was justified in moving, despite the father being actively involved in the child's life, which is an important factor under Tropea. And this was despite the AFC's recommendation that the father have primary custody, with the mother having visitation. I submit that the record, including the mother's own testimony, shows that she was doing everything and anything to get further away and to put up barriers. She quit one job to take a lesser paying job at St. Bonaventure, and it was not because she wanted to finish her education. She first had worked at Community Bank in Alfred. Alfred University is a 5-minute walk from where she lived. From where she worked. She never availed herself of the tuition assistance program at her first job. She never attended any schooling at Alfred. And when she moves to away so that she can supposedly get education at St. Bonaventure, she works there for she works at the place for 8 months. She never attended, she never completed her college education. She never took a single course. So her reasons for moving are, I believe, spurious. She quit that college job rather quickly. For this court's review, I would submit that the judge failed to properly weigh the Tropea factors. As noted on page 13 of my brief, the judge started out with the other considerations rather than the main considerations of Tropea, with the primary, not the prime factors noted in the Court of Appeals decision. The mother failed to show valid reasons for moving. She presented no testimony of economic need. She was going down, down, down in terms of her own income. The only thing that she showed was that she got married and that her husband had a job. He said that he had a good job. No economic indication of what he was making or what the situation was. He testified that they needed to live in the Ellicottville area rather than in some other area. Yet they lived together for about, I think, 6 months, and he was able to go back and forth to his job in Ellicottville. There was no economic reason shown. There's no emotional reason shown for her moving either. If she needed a support system, her support system was in Allegheny County. She had a mother, she had a sister, she owned a house. She still owns a house in Allegheny County. She now is living in a house in Cattaraugus County in Ellicottville that is not owned by the husband and wife. It is owned by her parents, by his parents. And the concern that I have is made very clear in the record and in the briefs is that she has made clear that they want to build another house in Dollars to Donuts. That place is going to be another 15, 20 miles further from where she is now living, so that's going to be even further for the
Is there anything in the record as to where the house is being built? I don't think the record revealed that, right?
No, Your Honor, it is not.
Okay.
But given her, where she has lived so far, it's going to, I would suggest that it would be further and that there's no constraints upon this mother of where she's going to relocate. She had no good reason under Tropea for moving out of county and further away. Now, one of the things I think that is very clear in this record, and the judge questioned the father's credibility. Why? Because the father is the manager of this plant, and he spends about half an hour. He's able to spend half an hour a day at the plant and do the rest of the work at home. And the judge.
I think the record reflected that those were the days that he had the child, that he would go in the morning, say hello with the child, say hello to the people at work, and then go back home and work from home. But when he didn't have the child, he worked 9 to 4:30 on a regular basis.
Correct, Your Honor.
I think that's what the record reflects.
Okay, but the judge, the concern that I'm raising is that the judge seemed to question his credibility that he could run a plant when he's not there all the time. I suggest that it's otherwise. And the burn that occurs in this case is that the judge is giving the mother props for spending more time with the child and keeping the child out of school, but when the father has the child and is spending time with the child on the farm or doing other things, that the father is being criticized for that. So there seems to be an unequal scale that is occurring here repeatedly. I respectfully submit that there are differences between the record and the mother's brief that I've outlined in my reply brief. And there's a number of other things that I would defer to the ASC, who, for her oral argument, that's contained already in her brief.
Thank you, Counsel.
Thank you very much.
Good morning, may it please the court. Mary Ann Connell on behalf of the child here. I would adopt all of the eloquent arguments made by Mr. Muldoon and let the court know that my client misses his father. With all due respect, I think the trial court got it wrong. I think the analysis of the Tropea factors as well as the primary placement and best interest factors, I think he got it wrong. The mother's relocation significantly impacted the time that my client had with his father. He went from 50-50 time with his father to de minimis time. It went down, I think, to about a third of that. And these are critical years for children and child development. And to take all that time away from both of them, I think was wrong. As has been indicated, there is no economic, emotional, or educational benefit that the mother could show. She didn't have any, she minimized all of the father's good qualities, such as having time to spend with his child, having flexibility in his schedule. She minimized all of that. And
well, I mean, I think what happened is she was pointing out that there were different earnings values here, I think, right? The father valued very much being able to have the child with him a lot of the time when he had custody, 100%, I think at one point he said in the record, he's with me 100% of the time. Where the mother was saying the child wasn't even being put into the daycare where he could socialize, get to meet and learn how to deal with other children, and there was some value to that the father didn't understand, right?
But I think, though,
So I
the
don't think she
father
was minimizing necessarily, she was just demonstrating a difference in their values.
But when the father wanted to put my client in Montessori, the mother objected because that would limit her time and that wouldn't be fair to her. So the father wasn't saying, I'm not putting him in any day. I would prefer not to, but if you want to do something, sure, let's do Montessori. Radio silence from the mother on that one.
Yeah, there was communication between, I mean, the father wasn't returning messages, and I think the court had trouble with that, the fact that the father was getting messages and not responding to them, and it made it very difficult for them to communicate, right?
It did, but part of his reason for not having difficulty responding was a lot of the texts were unilateral. Now you're meeting me in Belfast. Now you're meeting me here because I changed my job. The court order was very clear. She didn't go back and change that court order. She didn't apply to the court. She didn't even give him a decent explanation. She just said, not at that job anymore, meet me here. And he did, because he, in the way I read the record is, was non-confrontational with her to the point where, should they have been in co-parenting? Should they have been doing this? Yes, but the remedy isn't move my client effectively 3 hours away. The remedy is, as in most cases, it's not the child, it's the parents. Have the parents do something, not move, because that doesn't help anything for my client.
We'll take a look at that, counsel. Thank you.
Thank you.
Yeah, please the court. Emily Vella on behalf of the respondent, Devin Harrington. I would contend, Your Honors, that the court did properly weigh the tropia factors in connection with this situation. I happened to be sitting in here when Mr. Muldoon was arguing on behalf of his client and said that Buffalo to Rochester was not that far. And the same argument was made in his brief with respect to this matter, is that the Ellicottville to Andover, Allegheny County was akin to a Buffalo to Rochester. People in the South Towns travel for a long distance to go places. It's just the way that it is. I think the court was in the best position to weigh the credibility and whether or not this was a good faith request on the part of the mother, I believe, is a credibility factor, and the lower court was in the best position to make that determination. The financial necessity, I don't think that's what the tropia court says at all. It's the financial need, and I think that minimizes the determination made by the lower court that this in fact allowed the mother to only work part-time and be at home with the child in her move. I think she recognized the need for a continued relationship with the father. She made a good faith attempt to tell him that she was in fact moving. She gave the required notice pursuant to the prior order of the court and got no response from the father. I think there's a sound and substantial basis in the record to permit the mother's move, and that the lower court was in the best position to make that determination.
Thank you, counsel.
Thank you.
Case 663, A.H. Wines, Inc. versus C6 Capital Funding. Proceed, counsel.
Good morning, Your Honors. May it please the court, I am Eric Benzenberg. I'm here for the appellants. This appeal presents an opportunity to correct and interpret CPR 215-6 in the plain language it was written, and in accord with Court of Appeals controlling precedent. CPR 215-6 explicitly states an action to recover overcharge of interest or to enforce a penalty for such overcharge must be commenced within 1 year. But as mentioned, Court of Appeals precedent demonstrates that the criminal usury law, which was asserted here and interposed in a plenary action by the appellants, does not trigger either of these events. First, with respect to Adar Bays versus Genesis ID, the court there confirmed that a corporate litigant cannot assert a claim to recover excess interest. In fact, cannot assert any claim to recover anything. That the sole remedy available to a corporate borrower under the criminal usury statute is having that transaction declared void ab initio. With respect to the second triggering event, to enforce a penalty, the Court of Appeals likewise, in Cesar Ali v. Harris, explicitly stated that seeking to have a transaction that's criminally usurious declared void is not a penalty. As a result, it was improper for the trial court to find that the claims asserted by the appellants in the lower court was time barred. With respect to the holding in Kennard law, it is important to note that the cases there that were relied upon, in all cases evaluating CPR 215-6 as applied to usury cases, do not lend any support and authority whatsoever to applying the one-year statute of limitations to criminal usury cases. We look there, the three cases that were relied upon, specifically Mill Street Realty, Chasman, and Glassman v. Zorif, those three cases all dealt with civil usury, where a person, a living person, is entitled to assert a claim to collect excess interest, and thus it would be appropriate for 215-6 to be applied and bar such a claim. With respect to the lower court's holding, the Erie County Court's holding Kennard law, to look to these three courses and make a drastic jump to say that these civil usury cases somehow bar a criminal usury defense is unsupported by law and is contradicted by Court of Appeals precedent on this matter. As a result, we hope that the court will take view of these things and the controlling precedent, and that neither, in no what manner whatsoever, that 215-6 can apply. The case is, as the respondent actually suggested, the case is remanded for further adjudication in the trial court.
Thank you, counsel.
Thank you.
Good morning, and may it please the court, Jacob Dieman from Carter, Ledyard, and Milburn on behalf of the defendant A.H. Wines. This court should follow its precedent in Kennard law. It was a clear holding of law that a usury claim to declare a confession of judgment entered on a merchant cash advance to be void for criminal usury was time barred by the one-year statute of limitations in CPLR 215-6. The appellant made a new argument today that wasn't made in their papers below. It wasn't made in their appeal brief. It's being submitted for the first time, frankly, on reply and in oral argument that there's apparently no statute of limitations to a criminal usury claim. That cannot be the case. This court's held that's not the case. The appellate division cases in Glassman, in Mill Street, in Cullen, all held that no matter the way the claim, the affirmative claim is framed, if it's based on usury, it's subject to a one-year statute of limitations.
Anything further on that?
I'm sorry?
Anything further on that?
I did want to address one point that was in their reply brief. They cited a case called Palmer versus Travis. I think they meant to actually cite People versus Stan Zhu, that's 34 New York 3rd, 357 from 2019, which said that for a deed that's procured by fraud, it is not subject to any statute of limitations. In addition to being submitted for the first time on reply, that case was sui generis, and that only applies to a deed, whereas other species of fraud have a statute of limitations called CPLR 213.8, which is a 6-year statute of limitations. So they cannot possibly be taking the position that CPLR 213.8 is rendered entirely meaningless. And in fact, the Third Department interpreting case law said that there is a, that when it comes to other species of fraud other than the avoidance of a fraudulently conveyed deed, there is a statute of limitations that applies.
I think we have that, counsel.
Okay, thank you.
Thank you. Case 664, Dixon versus State of New York. Wait 1 second, Counsel. Thank you. Proceed.
Good morning, Your Honors. May it please the Court. Katie McCarthy, and I'm here on behalf of the claimant appellate Valentino Dixon. Mr. Dixon was only 21 years old when he was wrongfully convicted, and he spent over 26 years.
Counsel, we're familiar with the facts. This really boils down to dismissal ultimately of the indictment, but on a motion. But the problem is that the problem the court saw below is that everything was dismissed other than the criminal possession of a weapon, the CPW, correct?
Yes, Your Honor.
Okay. So how do you address the issue with the statute when we're dealing with the fact that he wasn't all dismissed? There was still a charge left, and it appears to be proof on the record, at least at this stage, of the fact that he had loaded the gun in the car, drove the shooter to the scene, and the individual that did the killing got out of the car with the gun and did the killing. So how do we get around that?
If I could just address Your Honor's question in part. So I think with respect to the issue before the court here, it's actually quite narrow. It's what is the meaning of accusatory instrument under the Act in these circumstances? And as we briefed, that question has been precisely addressed by the Third Department in Jones. The Third Department interpreted the same language, accusatory instrument.
I don't think that's necessarily true. And if I recall correctly, isn't that the case where there was 2 counts in the indictment? There were 2 different dates, 2 separate crimes, and then what was dismissed was one crime that was independent of the other crime that was committed on a different day, I think maybe even a different year. And so there's where the distinction was there, is that those crimes relating to that date were all dismissed.
So, Your Honor, respectfully, in Jones, you're correct that at the time of the original criminal trial, the claimant had been charged with robbery and murder on the theory at the time that the murder was committed to cover up the robbery. Even though it was properly charged then, the circumstances that the Third Department was considering, which are analogous here, was the fact that in the interim, it had come to light that a different man had committed the murder. That changes the landscape of what the court is looking at. And so the decision didn't turn on the fact that it was committed on a different day. If the murder in Jones had occurred on the exact same day as the robbery, the outcome would have been the same. And that's because the test is articulated by the Third.
No, I think if he had committed robbery at the time of robbery, he killed the individual. We have felony murder, we have robbery there. Those two couldn't be separated.
But that's a completely different factual scenario.
Well, here we have an individual that has a gun, possession of a gun, drove someone to the scene, at least as of now, that's what we have in the record, and drove him to the scene, and the person took the gun from the car and went out and shot him. So you're saying what we should do is separate the murder from the earlier possession?
Yes, Your Honor. So first, with respect to what's in the record, we are at the motion to dismiss stage, and I think the lower court did improperly credit evidence without giving Mr. Dixon an opportunity.
Well, you withdrew your motion.
Well,
the original one. The original motion ultimately resulted in dismissal of everything. You withdrew that portion of the CPW, and therefore that stayed. I understand now you have a pending motion to dismiss the CPW, correct?
That is correct. So, our understanding is that the motivation at the time in front of the criminal court was whether, the state's position was that Mr. Dixon had possessed the gun at some point and therefore was arguably entitled to have been convicted of criminal weapons possession. And so that no one was looking at whether he was entitled to be convicted of that possession charge under this indictment. That wasn't the question before the court then. The court was looking at the consent that the people made to the dismissal of the murder, attempted murder, and assault charges because, as we now know, a different man committed those crimes. Lamar Scott committed those crimes. He pled guilty on the same day to those crimes. And that puts us squarely in the ambit of what the court was considering in Jones and what happened in Chalmers. When you have an individual like Mr. Dixon, who is indisputably innocent of a murder, and that he spent time in prison that he would not otherwise have spent for that crime he didn't commit, then the question is, what does accusatory instrument mean under the Act in these circumstances? The fact that Mr. Dixon may have, and I think this is a question not resolved at this stage, possessed a gun at an earlier time. There's never been any allegation or theory that he aided or abetted or otherwise had anything to do with the crime. As Mr. Scott allocated, Mr. Dixon had nothing whatsoever to do with the crime. We're talking about if you credit the state's version, a possession of the weapon at a different time in a different location with a different intent. The possession charge in the indictment was for the shooter on August 10th, 1991. It says, with the intent to harm, to wit, Toriano Jackson, the victim. There's no question that the accusatory instrument, the underlying accusatory instrument, was for the shooter, right? That was the people's theory at the time, and that was appropriate then. But under the facts that we know now, there's no question that Mr. Dixon could not be charged with that accusatory instrument. Those are crimes committed by Scott. And so that is why we believe that the court in Jones did reach the right result. These are the exact same circumstances here. We have a different man who committed the crimes for which Mr. Dixon was wrongfully convicted and incarcerated.
Well, but, I mean, and they didn't pursue it back then, they didn't have the defendant. They could have gone under potential Section 20 accomplice liability. But I mean, so we don't have that scenario, because back then they only had one individual that they went after, and so we don't have that. So we recognize that. So what we have to do is you want us to take a look at the possessory of a weapon that occurred prior in time, even though it happened to be the same day around the same time, is analogous to the Jones case.
First, the possession of a weapon that's later used in a crime at a different time and different date has no bearing on Mr. Dixon's guilt for the crimes for which he was convicted, and as the state has conceded, wrongfully convicted. But also here at the grand jury, there was evidence that Lamar Scott was the shooter. There were two witnesses who testified in front of the grand jury that it was Lamar Scott, not Valentino Dixon, who committed the shooting. And I think that the people's charge to the grand jury is instructive here. They said, first consider whether you believe Lamar Scott is the shooter. If Lamar Scott did it, then you don't have to vote on Valentino Dixon. This indictment was for the acts committed by the shooter on August 10th, 1991. That, as we now know to a moral certainty, was Lamar Scott, not Valentino Dixon.
I think we have that argument, counsel.
And if I could just briefly address...
Very briefly.
Yes. So the state here has argued that Jones and Chalmers do not control, and the state has done so without offering any meaningful basis to distinguish those cases. For one, the waiver of sovereign immunity in the Act does not mean that a hyper-literal interpretation controls. That's clear from Court of Appeals precedent, in particular in the long case interpreting the proviso clause, but also the state made the exact same arguments in Jones. The state's briefing in Jones, the state's oral arguments in Jones were the same as here, saying that the plain language has to control. And the Third Department squarely rejected those arguments because they said, we know today that this man didn't commit the murder. And if anything, this case is more clear-cut. In Jones, there's no question that, in fact, Mr. Jones did commit the robbery that's charged and stood in the accusatory instrument because he pled guilty to it. Mr. Dixon has never pled guilty to any crimes arising out of this shooting. And to the extent that the court has some concerns, we have a 440 motion pending. The state's brief has said that this is premature. We should go back to the criminal court. Mr. Dixon has done that. The court has determined that he's made a prima facie showing of innocence, entitling him to a hearing, which has been set for January 5th of 2023. And so if the court would prefer, you could hold in abeyance pending the outcome of the 440 hearing.
Thank you, counsel.
Thank you.
There's a lot to unpack there, but I'll do my best to do it quickly. The question of whether or not the criminal possession of a weapon in the second-degree conviction should stand or should not stand, because maybe the prosecution is relying on a different theory. is one that's not for the Court of Claims to untangle. That is for the 440 court to untangle. And so the Court of Claims is just looking at the papers that are submitted, in this case, by the claimant. The claimant submitted the papers, the 440 motion and the transcript of the 440 hearing. The claimant submitted the affirmation in opposition to the 440, which was submitted by the district's attorney's office. And in that affirmation, the district attorney agreed that 3 of the 4 convictions should be vacated, but did not agree as to the criminal possession of a weapons charge, because the district attorney's reinvestigation determined that the claimant had packed the Tech-9 machine gun into his car and drove the murderer to the scene. Now, whether or not that's a different theory and that ultimately that conviction will stand or not in the 440 court, we don't know. But it's not for the Court of Claims to sort out. And I don't think there's any reason to hold this case in abeyance. It's very speculative. We don't really know what's going to happen in January. You know, he could win his 440 motion, but he could win it on a ground that's not enumerated in Section 8B, which to entitle him to move forward. And also, given the fact that the DA reinvestigated the case and apparently accumulated other evidence pointing to claimant's guilt, if not as the actual shooter, obviously, but as it's somehow involved, it's very possible that he could be reindicted. So there's no reason to hold the case in abeyance. As to Jones doesn't apply here. It's very different. And I can say that, you know, many of the arguments in Jones were made the same arguments because I made them. But I can tell you that Jones was very different in the factual scenario presented. In Jones, Mr. Mitchell was robbed in October of 1996. In February of 1997, Mr. Mitchell was found murdered. Jones and his co-defendant, I forget his name at the moment, but Jones and the co-defendant were convicted of both the robbery and the murder. And when a gentleman in Ohio came forward years later and said, no, I committed the murder, well, it was reinvestigated and the convictions were reversed, were vacated on the 440, and then Jones ended up pleading guilty to the robbery, which they did commit. They committed the robbery, but they didn't commit the murder. These events happened very separate in time. So what the third department did is they say, you know what, these are separate events. The separate events is the key to Jones. It's also the key to Chalmers. They're separate events. So the court is saying, look, these are not joined, they're not together, they're not the same. We're gonna allow a claim to go forward on one set of events if he's been exonerated on the one set of events. That's not what's going on here. Here, it's the same set of facts. I didn't put in these papers. The claimant put in these papers. The claimant put in the affirmation from the district attorney's office saying that the claimant drove, the reinvestigation showed that the claimant drove the weapon and the murderer to the scene. Whether or not he ultimately prevails in a 440 motion, I don't know. But his claim right here before this court is not sufficient.
Thank you, counsel.
Thank you.
Case 665, 315 Ship Canal Parkway LLC versus Buffalo Urban Development Company.
Go ahead. Thank you.
Good morning. May it please the court, counsel. Congratulations, Judge Sentra. I listened to your speech. It was great. Look, I think we're on a very limited question here standing. Everybody's thinking, okay, they're building the solar park, it's almost done, so why are we bothering? That's Justice Ward's problem if you decide we have standing, not your problem. My client has standing, investment plus proximity in a commerce park that they had just announced their second building in there, and 10 days later, a project that had slogged around for 19 or 18 months, all of a sudden flips to a solar park. My client, 2 days after Christmas, writes a letter, and I can't say it better than he did. It's at page 59 and 60 of the record, of why this was a bad idea, but also why it's going to hurt the park. We don't want to have Detroit here. We want to have commerce parks that have commerce. You don't get commerce from solar panels. Nobody comes in, no businesses come in. It's just one time, there's some construction, labor. They even admit there's no jobs. This is a development agency that's supporting a new project with no jobs, no tax base, no commerce.
Counsel, the question I have for you
Sure.
is basic before we get to that. Is this issue moot?
That's why I'm saying, Judge, no, because
I understand.
the best example, and I think Judge Whalen will remember it, Judge Elfin had a case in Buffalo with the post office in Benderson. They built a post office on Hurdle Avenue. He told them to tear it down because they violated the rules, and that was a deed restriction. Here, if you don't, and then there's two exceptions that are applicable to the mootness. One, it's evading judicial review otherwise. That's one of the exceptions. And two, this question will come up, because if my client doesn't have standing to challenge this action, where they should have just gone back to the drawing board and started over. If they couldn't build that building, they shouldn't flip it in a matter of 10 days over Christmas to get this result. Go back to the drawing board and see what happens. We even put in a bid in February and said, we'll pay more to stop this, because this is a waste of the park. We're in the park. We need the park to develop commerce, or it goes away and our investment sinks. That's why we're still fighting.
We'll take a look at that, Council.
Thank you.
Morning. Brian Quitt for Uniland Development Company. The appeal is moot, and I think as Mr. Walsh just said, they wanted to stop the building of a solar power field. That's what they wanted. That's what the petition speaks to. And in fact, I flagged some pages, although Jerry covered it already. I mean, the petition reads of, a solar park is a waste of valuable development resources. That's on page 16 of the record. So they wanted to stop the transfer of land to Uniland Development, and they wanted to stop the building of a solar field. Both things have happened. The land was transferred, the solar park, and to give you updates as of where we are today, all equipment is in, all the site work is done, all the panels are installed. The only thing remaining is they're wiring the panels for National Grid. But the work's done. So we get to mootness, and I think, and we did this on a motion to dismiss, and it was denied without prejudice for leave to really re-argue today. But, we have a change in circumstances that renders, there is no actual controversy remaining. And three things to look at, and I'll do this very quickly. How far has the work progressed? So, as I just said, we are done other than some wiring. Number two, can the substantially completed work be readily undone without undue hardship? No. About $7 million has been spent to do this, so it's significant hardship. And then the chief factor, and it goes to this court's decision in the matter of Sierra Club, the chief factor, according to the Court of Appeals, is whether the challenger has sought preliminary injunctive relief to otherwise preserve the status quo to prevent the construction from happening.
Clearly, they didn't do that.
Did nothing,
And
at no stage.
They argue that it was because they weren't going to succeed, so why should they do that?
Well, but that goes to the point, right? I mean, you needed to do something. Mind you, the Ship Canal Place is directly next door to what Uniland is building. They've watched this go up. I mean, think about it. We filed a motion to dismiss this thing early in '22, and raising the point that they didn't seek any injunctive relief at any point, and they still haven't done it. They've watched this thing go up all through 2022, and nothing, and they've done nothing to stop it. And that primary factor, that chief factor, according to what this court said in Sierra Club, renders this whole appeal moot.
Thank you, Counsel.
Good morning. Andrea Shalacy on behalf of the BUDC. I think most of the points have already been covered, but I'd just like to address the fact that the burden of proof for establishing standing is on the appellant, which has not been met by any stretch. The cases relied on relate to zoning, which this is not, relate to seeker, which this is not, and there's no environmental harm alleged. And I would just note that in the case cited by Mr. Walsh regarding the post office, there was a deed restriction, and there is no deed restriction here as well. So it's our position that there is no standing and that the case is moot as well.
Thank you, Counsel. Case 666, Capizzolo versus Capizzolo.
morning, Your Honor. May it please the court. Kenneth Olina for the defendant appellant, Arcangelo Capizzello. I'm here today in connection with an appeal from a contempt sentence issued by Justice Jeanette Ogden on November 23rd, 2021. At the time of the proceeding, and the transcript is in the record, Justice Ogden recused herself from further proceedings in this matter. However, she continued with the sentencing on the contempt, stating that the determination had been made prior to the incident causing her recusal. The difficulty I have, Your Honor, is that the sentence she imposed is substantially different from the sentence previously imposed and was the subject of a previous appeal. He had been sentenced to 3 weekends previously. This time he was sentenced to 30 days. And I would submit that that was a punitive sentence, not a coercive sentence.
And did you make that argument ever, anywhere that we can see in this very brief record?
I'm sorry, Your Honor.
Okay, back in Supreme Court at some point in time, did you make that argument about the sentence, the nature of the sentence?
Not at that time, no.
Okay, so why can you bring it up now? Okay, you know.
Okay. No, I understand the question. The reason it can come up now is there was no opportunity at the time when this happened for any discussion or argument. Judge Scanier issued her ruling, and that was the end of it.
Judge Ogden. You said Judge Scanier. Judge Ogden made the ruling. Okay.
I'm sorry, I
Are you having
can't hear a
difficulty
thing.
hearing, counsel?
Excuse me?
Are you having difficulty hearing?
Yes, I am, and I can hear you, but I can't hear Justice Bannister.
I'll speak a lot louder if I could.
Thank you.
All right, so the argument you make now is about the nature of the sentence.
Well, there are two arguments. One, after the recusal, or because of the recusal, there shouldn't have been any sentencing at all. And secondly, given the circumstances that were well known to Justice Ogden, there was no coercive effect of any sentence. He's in bankruptcy. He was given no opportunity to purge, either a reasonable opportunity to purge or even an unreasonable opportunity to purge. And for that reason, it's our position that the sentence was punitive and not coercive and should be reversed.
We'll take a look at that, counsel. Anything further?
Thank you very much.
Case 669, Listener versus Veneni. Proceed, counsel.
Yes, thank you. Good morning, Your Honors. May it please the court, Matthew Albert, on behalf of Ms. Leisner, the plaintiff appellant in this matter. Judge, the doctrine of stare decisis, sacred as it may be, should not betray either one's common sense or one's sense of humanity and decency. Furthermore, to its credit, it's a far more subtle and flexible concept than some of those who would give it slavish adherence suggest, and that's not me speaking, that's Justice Fusberg in the Higbee v. Mahoney case. The opposing respondent's argument in a nutshell is, this is the way it's always been, this is the way it always has to be. Animals should be considered personal property. One can't be compensated for emotional damages due to the loss of one's personal property. But if we were to just think of this from a common sense perspective, and you ask any dog owner in this room or any other room, because animals bring out the best in our humanity, they transcend age, any socioeconomic factors, race, anything else. And you ask them, you told me do not put my dog in this dangerous situation. And I said, okay, no problem, and I did it anyway, showing a conscious disregard for your dog's well-being. And your dog perished as a result thereof. And then, afterwards, I decided, I'm gonna cover this up, I'm gonna burn this dog, I'm gonna cremate this dog and incinerate this dog, and I'm gonna lie to you about what happened, and I'm gonna cover up evidence. And then, for whatever reason, after the fact, I'm going to
Counsel, we're familiar with the facts of this case, right? The record's not huge, and we're familiar with the facts of this case and have gone through it. Why don't you hit the legal points that you need to hit?
Certainly, Your Honor. The prior precedent in this department is completely inapplicable to the matter at hand. DeJoy v. Niagara Mohawk Power Corp., wires falling onto a fence, negligent action causing livestock to be electrocuted.
Counsel,
you appear to be in your brief focusing on the intentional reckless, right?
The recklessness,
Okay,
correct, Judge.
Okay.
Yes.
So based upon that, we here, we look at what we know, the elements we need to look at, and whether or not, as Justice Whalen pointed out, we're familiar with the record, was not a big record.
Right.
But conduct, was it outrageous in a degree? Did it go beyond the possible decency? You know, all those other factors, we need to look at whether or not this conduct of this individual, which listen, I feel for the plaintiff in this case, I really do, because, you know, I'm a former dog owner, and so is my colleague up there. But with that being said, what we have to look to, did that conduct rise to the level that meets the standard for us? That's where the legal point, I think Justice Whalen was alluding to, is that you have to hit it home.
Well, that's where I was trying to go with that analogy earlier, because I think if you ask any person that this happened to, any dog owner who this would happen to, not just distilling the dog's death, but looking at everything else, all these aggravating factors involved, and then ask them, hey, did so-and-so act outrageous? I think the universal opinion would be absolutely.
Yeah, but the definition of outrageous of an ordinary person as to what outrageous has been defined by case law is really what guides us.
And I think everything's on a case-by-case basis. There is no case directly on point to what occurred here. For the sake of other dog owners in the state, I hope there never is. But we are talking about recklessness in the sense that this risk was brought to the defendant's attention, the respondent's attention, and he disregarded that risk. That reckless action, and that's the definition of recklessness under Everett v. Loretto Adult Community, Inc. in this department, set forth in the brief. So we have recklessness there, then we have a continued course of conduct, and as I've stated, Your Honors, if this was a situation where this incident occurred and the defendant was conciliatory, apologetic, we might not be to an area where a fact finder, a reasonable fact finder, could find outrageousness. I don't know. I would argue we could, but certainly there's a good counter-argument to the contrary. Yet, the burning of the dog, the cremation of the dog, and all those aggravating factors, I think certainly get us to the realm of outrageousness and beyond, given the standard in this instance, where can a reasonable fact finder find that the defendant's conduct was outrageous? Again, the stalking and harassing type behavior, and that's why this is so much more than just what happened to Oakley.
Was it Barnish? Is that the case?
Barish v. Chiesa certainly sets guiding precedent in the first department that the intentional infliction of emotional distress, where it was the killing of the animal, an intentional killing, but that and that act alone constituted a prima facie case for the intentional infliction.
Yeah, okay, but in that case, if I recall correctly, the cat was tortured, killed, and left for the plaintiff to find.
Yeah, the cat was killed in this instance.
No, the words were, cat was tortured.
Okay.
There's a difference between, cat was tortured intentionally by the individual, tortured by the person, okay, and then ultimately killed by that person, and then left for the plaintiff to find by that person.
We're certainly talking recklessness in this instance. There's no allegation that the defendant intentionally killed Oakley. Yet did he show conscious disregard for Oakley's well-being? Okay. Absolutely.
Fair enough.
And so what I'd say there as well, Judge, is there is now, serendipitous, if I'm saying it right, serendipitously enough, a case in this department, recent ruling, which honors and dignifies one's ability to be recompensed for the emotional distress they suffer due to the reckless actions of another, which leads to their pet's demise. And I cited that case.
Why don't you go to your economic damages? That was dismissed too, right?
Well, and that one I think is a pretty clear call, and I think the case I cited there, Brown v. Government, 156 AD 3rd, 1087. In that particular case, there was a breach of contract where there was also an emotional distress claim thrown in there. The lower court wiped the whole thing out, and the third department reversed the lower court and said no. She could certainly seek special damages due to the breach of contract, or the plaintiff could certainly seek special damages, economic damages, relative to the breach of contract issue, just not emotional distress. So I guess that would sort of be splitting the baby a little bit. My focus here, as you know, I think would be on the one's ability, as recognized within this department by a Monroe County Supreme Court judge at this point, and that's the Lamas v. Pietrantoni case, to be awarded emotional distress as my client suffered. Certainly, I think she should also be entitled to pursue the economic damages, and those were pled in the complaint relative to how much she paid for Oakley's market value at the time of death, and so forth.
You should wrap up, counsel.
Yep, that's all I have unless there's any other questions.
No questions? Thank you.
Thank you, Your Honors. May it please the court, Michael Shug on behalf of the respondents. I will be brief. I'll start off by saying, first of all, that personally I love dogs, but I love the law more. The lower court, I think, got this decision correct. They were consistent with the precedent, and the decision should be upheld. There's only 2 points that I'd like to make, and I'll defer the remainder to my papers. The first, I don't necessarily know that the court is going to reach this in its analysis. However, I think it's important as to context. So it's not addressed in my brief conceitedly, but the claim that in asking the court to analyze the totality of the circumstances rather than just the destruction of the dog as being the impetus for the intentional infliction claim. The claim starts in the appellant's brief at, there's a bullet point, A through F, of all of the things that my client allegedly did wrong. It starts off by saying that he was operating a business unlawfully based on Executive Order 202.8. And frankly, that just appears to be incorrect, since animal shelters, as this was, a doggy daycare, is an essential business, and that was exempted from that requirement. So I think that provides the court with some context as to the substance of the allegations that are being made in this case. But ultimately, again, it's understood that you're entertaining a decision on a motion to dismiss a complaint, a pre-answer motion to dismiss. The second point that I'd like to make, Your Honor, Justice Sentra, you already hit on it. The Barish versus Chiesa case, it's light years away from what is being alleged here. It does have language. It says, quote, a plaintiff can recover damages for emotional distress arising out of the intentional destruction of property. There's 2 points that I'll make, one of which I just said, that's it's what's claimed here and what's claimed there are very different situations. That decision, there was an intentional torturing and leaving of a cat for a plaintiff to find. That's not what happened here. But I think more importantly, the legal point there, the First Department, in concluding that someone could recover such damages in that specific case, relied on Weitzman versus Weissman, which was a Second Department case. I do mention this in my brief. I think the reliance on Weissman to support that proposition is misplaced and flies in the face of longstanding precedent, not only in this department, but in multiple departments around the state.
Thank you, counsel.
Thank you, Your Honor.
Case 670, Stoneham versus Barzuk, Inc.
Morning, Your Honors. John Lipsitz for the plaintiff appellants Mark and Bonnie Stoneham. In this Labor Law 240 sub 1 case, the core of the defendant's argument is that work on vehicles, a broad range of objects, must per se constitute routine maintenance, and that vehicles can never, as an entire category, be considered structures for purposes of the statute. In this department and throughout the state, the law with respect to whether a work activity is a repair or routine maintenance is generally determined on a case-by-case basis. And the same goes for whether an object is a structure. Even after the decision of the Court of Appeals in Dahar, which is heavily relied upon by the defendant, there's a number of cases which, in wake of Dahar, say it's a case-by-case multifactorial analysis. And in that case, Dahar, and I would like to just take a moment before I get into Stoneham, there the plaintiff was injured when he fell from a ladder while cleaning a steel wall module in a factory setting. This case actually originated in Cheektowaga, New York. The product itself was manufactured by the plaintiff's employer, By contrast, in Stonem's case, plaintiff was engaged by defendant in repairing the brake system on a large multi-ton commercial trailer when the trailer, which was improperly secured by the bucket on a front end loader, collapsed on him, crushing his pelvis. Now we're talking about an object 35 feet long, 8.5 feet wide, capable of hauling 20 tons of freight, and that was not self-propelled. It's not an automobile, it's a vehicle with wheels. Stoneham customarily performed repair work on heavy commercial equipment used in the construction industry, including excavators, dump trucks, trailers, bulldozers, and also loaders, and was such as the one that was used to hold up the trailer that crushed him on August 18, 2018. Stoneham did not work in an automobile service station or garage replacing wear items like worn-out brakes or tires. On the day of his injury, he was outside in a loosely regulated work environment suitable for the protections afforded to workers by labor law section 240 sub 1 to guard against the inordinate dangers encountered where there is an elevation-related differential. Let me go now to the distinction between repair work and routine maintenance. In 2006, this court affirmed a decision of Supreme Court, Erie County, a decision by Justice Peridotto in a case called Bissell versus the town of Amherst. In that case, the trial court held that whether a worker is engaged in repair work or routine maintenance under section 240 sub 1 may be a question of fact, and that, quote, generally, work is repair if it involves fixing something that is malfunctioning, inoperable, or operating improperly. However, the work is routine maintenance if it is caused by a common problem, is a result of normal wear and tear, or is done as part of scheduled maintenance. In Stoneham's case, a hole in the air tank of the brake system rendered the trailer itself inoperable. Now, Mr. Stoneham went on behalf of Mr. Barzak in the spring of the year to retrieve this trailer from which was purchased, I think, in Watertown, New York. He brought the trailer back. It was operating fine. It looked fine. He examined the air tank and the brake apparatus. It looked fine too. It didn't have any defects. So the important thing is it was operating. So he was grievously injured when he was fixing it on August 18, several months later. Didn't discover that there was a leak or a hole in the air tank until July.
Counsel, do I have the facts right here? There was an episode that occurred prior to the date of injury where Barzak used a lift equipment to lift up the end of the structure that you're referring to, right?
August 4th.
Yeah, to get to the damaged piece, the air tank.
Right.
We'll call it.
And at that point, Mr. Stoneham removed the damaged item.
But no injury occurred at that point.
No, not that point, Your Honor.
But the repair that had to be done and took place, and then it had to be reinserted into this, right? But did your client at that point use the same lift or a similar lift to lift up the structure?
It was a similar, if not the same lift, but instead of having, it had a bucket on it when my client operated it. It was a front-end loader.
Right.
And it was used to lift up 5.5 feet in the air, lift up the trailer.
So your client could get underneath.
Or he'd get underneath
and be able to operate or do the work he needed to do.
Which he did on August 18th, on the date of the injury.
Right.
So he had purchased a new set of hoses and an air tank. It was an assembly. He lifted the trailer up using the same method that was used on August 4th when he was there with Mr. Barzak, and they lifted it up so that he could take out the old broken equipment.
And we know that obviously something moved or shifted that allowed this structure to fall on your client and pin him for many hours, right?
About 4 hours,
yeah.
And on August 18th, when that happened, the front end loader, which was not locked into place with appropriate blocks designed for that purpose, to keep these large, heavy construction pieces of equipment from moving, it moved. And the trailer itself, which should have had stanchions or jacks under it to keep it from collapsing on Mr. Stoneham. They weren't there. There were neither the appropriate blocks to use for the purpose of keeping the front-end loader from going back and forth,
Well, something wasn't done properly to make this a safe environment for him to work under. My question, though, goes to this, that this is a 240 sub 1 case.
Correct.
Right? Your client at the time that the accident happens is on the ground, right? Is on the ground, he's underneath the structure.
Yes, he is on the
right?
ground. Yes.
He's not on a ladder, he's not on a scaffolding, he's not.
It's an object falling, it's an object that falls.
That's my question. So you're relying on the language in the statute which resulted in falling objects on top of him.
It's gravity-related, elevation-related, 5.5 feet, collapses on him, crushes his pelvis.
And he's working on a structure. The structure you're talking about is the equipment that fell on him.
Well, yes, it's the trailer, Your Honor. I mean, under the classic definition of structure, which has never been undermined or altered or modified, and it certainly wasn't by the decision of the Court of Appeals in Dahar in 2012, but you go back to Caddy, decisions frequently cited, I think it was 1909 or 1911. In that case, the Court of Appeals said, you know, it's a thing that's composed of various parts that are bolted or put together, and it's an assemblage.
These are sometimes frustrating cases, counsel, when we're trying to define what is a structure, what isn't a structure, and that's where we are here today, right?
There's some guidance, Your Honor, in a case that was decided about 7 months after Dahar, and that's a case that was decided by the Second Department in McCoy versus Abigail Kirsch, and that involved a wedding canopy, a Jewish wedding canopy called a chuppah, and the worker was dismantling it. It had pipes and it had pieces of metal that went vertically to hold up a canvas. And the defendant argued, well, when the worker fell off the ladder, disassembling this thing, he said it wasn't a structure. Well, the court said, no, it was a structure. And the court said it's a multifactorial analysis. You got to look at this on a case-by-case basis. Now, if that impermanent temporary structure in that case was deemed a structure, well, we're looking at a multi-ton, 35-foot long, 8.5-foot wide, a thing that's capable of hauling 20 tons of freight. That's got to be a structure. And the only way you could say it was anything other than a structure is if you categorically rule it out and say, nope, can't be a structure, it's a vehicle, whatever that means.
We'll take a hard look at that, counsel, believe me.
Okay.
Thank you. Anything further?
Well, Your Honor, I would just note that the trial court found that there was a question of fact with respect to whether Mr. Stoneham was an employee. And Mr. Stoneham testified at his deposition that he did this work in part, well, not in part, he did this work in order to work off a debt.
Well, there was a loan.
Right.
Right, and the idea was that the time that he was spending on this job was going to reduce the loan amount that he owed to the Barsiks, is that right?
Correct. And there's just one little section that apart from his testimony, which we cite in our papers, where he says exactly that, and then he repeats it in his affidavit in opposition to the motion, but he said it at his deposition. He also said, in response to a question at the record at page 336, question, had Mr. Barzik told you you could not use it, would you have listened to him? Yes. Had he told you that you could not come over and install the new tank without him being there, would you have listened to him? Answer, yes. This was at his deposition, and this goes to whether he was permitted or suffered to work on the premises. And our argument is absolutely, and in any event, if there's a question, it's a question of fact to be resolved by the jury and not by a court on summary judgment.
Counsel, thank you.
Thank you very much.
Good morning. May it please the court. James Special for Mr. Barsuk. I'll actually briefly start with the last point first, about whether or not he's a volunteer. I actually think that might have been our strongest argument, even though we did end up losing on that one. Here's why. There's that one question at the end where that they cite in their reply brief, couple of objections to it. Because the question is was it compensation for the loan in your mind? That's not really the same thing as saying, was there an employment agreement, which is a two-way street, where both parties,
Let me ask you a question, and I'd be curious. Assume there is a loan, right?
Yeah.
Barzak loans was $10,000?
No, it was
$25,000, that's right, $25,000 to the plaintiff here, right? And the idea was, look, you can pay me back over time. There's no set, monthly payments, and there's no interest rate. There's none of that established, no promissory note, no documentation other than you're going to pay me back. And let's assume for the sake of argument there's a conversation that you're going to do work for me, and I'm going to give you credit for that work against the loan. Would that be an employment agreement? Or are you saying that's a voluntary, working for him as a volunteer?
Would that be an employment agreement? I could see where it would be, but here, my real complaint is that when we questioned him during his deposition, all of his answers were in favor of us that he was a volunteer. He didn't consider himself an employee or an independent contractor.
Does his opinion, other than him testifying as to the facts, does his opinion of whether or not he believes himself to be an employee versus a volunteer, does that really carry any weight with us, or should it?
Yes, because it's confirmed by Mr. Barsuk's affidavit as well. There was an understanding that these two men were friends for a long time, constantly did very large favors for each other for years. When we have all of this evidence, when we asked him the open-ended question, not just if in his mind at the end, when his counsel asked him that, when we asked him what was the work that was compensation for this loan, he didn't mention his work on the trailer, although he mentions other jobs. Also, he says, I plan to pay back the full loan, which seems strange, because if you worked some of it off, why are you paying back the full loan?
Counsel, we'll take a look at that.
Yeah, sure. And as far as the vehicle issue, I think here we can tell the difference between when a vehicle is a vehicle and when one counts as a structure, because the legislature defines vehicle as some things and not others, and even some things that we may think of as a vehicle aren't, like rail cars. In VTL 125, it exempts rail cars. So my point there is there's a very specific definition of what a vehicle is and what a vehicle isn't in the VTL. If the legislature wanted that to apply in 440 cases, they already have a definition. They could have put that word in there at any time, and they haven't. So to me, this whole thing just sounds like a job for the legislature. They easily could make it apply to cars, to trucks, whatever, if they wanted to, by adding a word to the statute, and they haven't. And when all of the cases, frankly, that both of us cite, I don't think any of them were really truly factually right on point. And I think that's why the trial court pointed to the second DE Department cases, Strunk and then Guevara, because really that's the only case where that I could find where there's a nice clean rule that simply says, as far as automobile maintenance, 240 doesn't apply. And here, since the trailer, the legislature decided to include the trailer as a vehicle right along with a car that you and I drive, it counts as an automobile in my view.
We'll take a look at it.
Thanks.
Thank you. Case 671, Bolt versus New York State Office of Temporary and Disability Assistance.
Hey, please court. Good morning, Your Honors. Bradley Sam. I represent the petitioner, Linda Bolt, as the administrator of the estate of Doreen Barr. I know everyone, perhaps the last one here or close to the last one here, so I will.
No, you're the last one here.
Okay, I'll be very brief.
But
Your
you
Honor.
don't feel like you have to be, quick because you're the last one here. Make your argument.
Last but not least, as they say.
That's right. Thank you. As Your Honors know, the Department of Health, their main argument is threefold. This was a lump sum transfers, if you will, and they're saying it violated the care agreement. The logs apparently weren't enough, and the receipts for the talk
Mr.
about
Stan, let me
house
ask you a
repairs.
question. We got the agreement that's written up, right? So, and then there's an effort, I think, to undertake a daily log, or a log, we'll call it, of efforts undertaken, right?
Oh, yes.
And the word meds appears, the word, so there's notations in the log as to what's being done on particular days. And I think the question becomes, how detailed does that log have to be in order for it to qualify? Am I asking the right question?
Your Honor, it's a wonderful question. That's never been decided.
Okay.
That's the thing. In fact, there's case law that says these logs aren't even necessary. But what they do is they provide the ability to show what was done for the payments, the whole fair market value argument. Right. This log, Your Honor, might be the most detailed log I've seen in these cases. I mean, Your Honors have all seen this.
Right.
You're talking done on the calendar, but even on weekends, you're listing 5 or 6 different things.
But is that indicating how much time it took to do those things, and does that matter?
Your Honor, because they live together, I think it would be very difficult to say, it would be difficult to say it took me an hour to prepare the meal and an hour to help the person eat it or give the meds took 45 minutes. But when you're looking at the totality, which is really the point here, they cared for this woman 24/7 in her home for years and years and years and years and years before she ever got to a nursing home. And when you look at the totality and the fairness.
Well, the look-back period is what, 5 years?
5 years.
And in this particular point, we've got a period being covered through the logs of how long?
At least from October
4 years?
2015.
3.5 years?
Pretty much close to almost, about 3.5 plus. I think it was 39 months of care.
All right.
Which is a long time.
Right.
And, no one anticipates when you're going to go into a nursing home, if ever. Correct? So you're talking about very detailed logs with 24/7 care. This isn't like we're popping over for an hour and then we're going to go back home. They were living with this woman. And that's why all we're saying is, you know, for the amount of money, the care surpasses this by a ton. And it's being denied on grounds that we don't think are fair, number one, but also really don't make sense. The whole lump sum, and I'm just gonna, very succinctly, Your Honors, it wouldn't have made sense to take these transfers, put it into her bank account where she can't even write the checks, and to pay the $2,500 a month. And it was testified to by our consultant during the fair hearing. She said,
There's some indication in the record that when this initiative was set up, there wasn't enough money in the account to even pay for 1 month.
Exactly.
Yeah, and so the liquidation was required in order to fund this agreement.
And that happens all the time. There isn't money, and then you liquidate something, the money comes in. It's like a retainer, and then it, you know, the money is there for the care, and it all equals up, especially with the logs. If they didn't have the logs, it would be a totally different thing. But these are very detailed, accurate records.
I think we understand. Counsel, do you have anything further?
No, thank you, Your Honors. I appreciate it. My best wishes to you, Justice Sedgwick. Thank you.
Good afternoon, Your Honors. First off, we are not saying that the transfer violated the care agreement. We're saying that as a factual matter, we simply can't tell if it was done pursuant to the care agreement. My adversary is saying that it just makes no sense to provide for monthly payments, but the contract provides for monthly payments. If it didn't make sense, why do they have that in there? They provided for Mrs. Barr to pay on a monthly basis $2,500. There's testimony at the hearing that they changed their mind shortly into the contract. First off, I also want to say I don't know where this can't write checks comes from. This is the first time I'm hearing it, because they did, at least early on in the agreement, write at least one check, and the county credited that. They then changed their mind. They didn't execute an amendment. And we know, based on the hearing as well, that there are numerous transfers during this period, many of which are admittedly not done pursuant to the contract. So these transfers do not resemble the $2,500 payments. I'll admit that it might be a stronger case if, say, there was a $25,000 transfer 10 months in, and it was represented that was 10 months worth of $2,500 payments. But these don't reflect that at all. And
so just so I understand, so you're saying that the nature of the money that they took, right? When it was taken, how much it was taken, is vitally important because it doesn't comport to the $2,500 a month, which was scheduled in the agreement. It doesn't amount to every 6 months taking the equivalent of $2,500 a month, or every year taking a year's amount. There's no indication that they're following the payment plan in the agreement, and that's where you're having trouble with this. It's not necessarily that the service wasn't rendered and the monies weren't due. You're simply saying that the way that the money was taken didn't comport with the agreement that they entered into. Do I understand that?
There's a couple of things to unpackage there, Your Honor. So I want to make clear, we're not imposing or asking this court to impose a hard and fast rule that you always have to follow the payment plan in the contract. We understand that there are issues that can arise. What we are saying is that these are going to be factual determinations. And what we have here is simply nothing more than the consultant say so. She came to the hearing, she said, this is what happened, and the Department of Health, as a credibility matter, was entitled to say that's just not enough for us to conclude. The reason that I bring up the 10-month example is that would be an example where you might not have payments strictly pursuant to the contract, but you would have a stronger factual case. And maybe if something like that happened, that would be different. But here, where we have nothing but the say-so, and the transfer doesn't match up, and we know that they were, at least early on in the contract, following it, and we also know that they used it for other reasons, that was enough for the department to say that the $43,000 in redeemed insurance policies was properly assessed a penalty. We just couldn't determine that it was pursuant to the contract. Now, the services rendered That presents actually a distinct factual issue. So under the law that's developed with respect to these personal service contracts, even if a penalty is properly assessed, and we argue that it was, an applicant might be entitled to get a credit against that penalty, but the department's Medicaid rules, which both sides are asking this court to follow, they say you only are entitled to that credit if you provide credible documentation of the fair market value of the services that were rendered
And
under the
that's where you have a
contract.
problem with the logs not being specific enough?
Exactly, Your Honor. And so this is an issue. We
The $2,500 a month, is that something other than fair market value?
The $2,500 a month, Your Honor, may or may not have been fair market value. The problem is that we just don't get that far because we don't know what services were rendered, how much time was spent rendering the services. Your Honor pointed to timing when questioning my adversary, and that is critical because the contract itself refers to an hourly rate. That's the basis of everything.
So, counsel, are you indicating that you would require something akin to billable hours by an attorney, something that lays out precisely each block of time?
I don't think we need something that detailed, but there needs to be something at the very least to give a fact finder confidence that the fair market value can be assessed. For instance, let's look at meds and meals. That's the most frequent calendar entry. We don't know what meds Mrs. Barr was taking. We don't know how frequently. We don't know how they were administered. We don't know if it's just putting pills down once a day or if she needed an injection or something even more complex. With meals, we don't know if they were preparing, chicken cordon bleu from scratch or if they were microwaving a can of soup. There's differences in the amount of work that goes for this.
But we do know that from like age 89 to 94, that these people provided total care. She wasn't capable of taking care of herself. They have a log of what they did, and there was nobody else providing any of the services that she needed to survive.
We know, Your Honor, that there are logs that seem to indicate that there were activities provided. They were transporting Mrs. Barr to appointments. We know they helped her bathe. We know they helped with her hair, but they don't articulate how much time was spent doing that. There was an opportunity for them to do that, and that opportunity was the hearing. These logs raise questions, and if petitioner could have answered those questions, the hearing was an opportunity to do so, and she declined to do that. She appeared through the consultant, and the consultant pointed only to the existence of those logs, and it's for that reason that the Department of Health looks at them and expressly takes on this issue and says there's just not enough here for the department to determine that we can provide ourselves an offset. And I believe this is important because in these cases, I'll acknowledge that there have been a handful of cases where this court has remitted to give the parties an opportunity to provide fair market value for these services. However, those remittals do not occur where a party has an opportunity. And what we have here is a situation where petitioner had her opportunity to assess the fair market value of these services. And to go to Justice Winslow's question before about like the level of detail required, to give an illustrative example, had petitioner or someone else with personal knowledge came in and said, usually cleaning the bathroom takes an hour. And there's, say, I don't know, there's 10 entries through the 39th month period for cleaning the bathroom. Now maybe we can get close to estimating the fair market value of that. But we don't have that. She had an opportunity to do it. Even before this court, there's no indication that she could now come in years after the fact and provide this testimony. What we have is this overgeneralization that because she lived with her mother, she therefore must have been providing.
Counsel, anything further?
No, Your Honor, except to wish Justice Sentra a happy retirement. I've been here many times. You've always been courteous and thoughtful. I'm going to miss you.
Thank you, Counsel. Thank you.